Good afternoon and welcome to this afternoon's Pump Court Chambers webinar on constructive trusts and proprietary estoppel. It's a pleasure to see so many people in attendance. The structure of today's webinar will be in two parts. First of all, I will begin by discussing recent developments in constructive trusts claims. My esteemed colleague Helen will then give what promises to be an illuminating presentation on proprietary estoppel, and in particular how such claims should be quantified. She will also be discussing the potential outcomes of guest and guest, which, as you probably know, is currently on appeal in the Supreme Court. At the end, there'll be a short Q&A session, and you're invited to raise any questions you may have. Please type these into the chat box function, and we'll try to cover as many as we can in the time available. It's perhaps worth saying at this stage that in both talks there is a significant quantity of material to cover. The slides themselves are fairly comprehensive, and you should rest assured that copies of these will be made available to you after the webinar. We're also aware that attendees will have different levels of knowledge in these areas, and we've therefore tried to strike an appropriate balance. So making a start then on my presentation concerning constructive trusts, common intention constructive trusts. We'll begin briefly with the basics. In a domestic context, there are typically two kinds of cases: joint names cases and sole name cases. I say that these are the basics, but what I would emphasize is that it's easy to presume that we know the basics, but as the cases demonstrate, these are frequently overlooked, or at least the strictness of them is underestimated. The focus this afternoon will be on sole name cases, which for various reasons appear to have given rise to more reported cases over recent years. Where then do we start? Well, the court approaches sole name cases applying the well-known presumption that equity follows the law. And so in a sole name case, it's presumed that the property is also owned beneficially on a sole basis. The burden, as you will know, is on the party who seeks to argue that the legal title doesn't reflect the beneficial ownership. Again, the basics. Remember, there are two things to prove. A common intention constructive trust will only arise by operation of law where a party can prove two things. The first is that the parties had a shared common intention that the beneficial interest in the property would be held otherwise than in accordance with the legal title. And secondly, that in reliance upon that intention, they've acted to their detriment. You have to look at intention, and the case law has indicated that that can be looked at really in two stages. In a sole name case, first of all, to ask, has the claimant established that the parties had a shared common intention to share the property beneficially at all? If that's established, and in Jones and Curran it was said that only if that was established, then the court should go on to consider how the parties' respective beneficial interests should be quantified. Now, as we will come on to see, more recently, the courts have begun to question the wisdom of that approach, albeit that it still remains good law at the highest level. Let's look then at what needs to be established with regards to intention at the first stage. In a sole name case, as you can see on the screen, you can only rebut the presumption that equity follows the law with evidence of the parties' actual shared intentions. And so it's important to understand that at this first stage, the court cannot impose an intention on the parties that they didn't have, just because it thinks that it would be fair to do so. The court, therefore, has to confine itself to the parties' actual intentions, which can be founded in one of two ways. either by finding evidence of actual discussions between the parties about the ownership of the property, or secondly, by inferring that intention based on their conduct. And it's this part we're going to come on to consider in a little more detail. But before we do, I think it's worth just reminding everyone about how that process works. In as long ago as the 1970s, Lord Diplock described the process of inferring intention from conduct in the following way. He said, the relevant intention of each party is the intention which was reasonably understood by the other party to be manifested by that party's words and conduct, notwithstanding that he did not consciously formulate that intention in his own mind, or even acted with some different intention, which he did not communicate to the other party. And trying to break that down, in other words, the question is, what would a reasonable person in the position of the claimant take to have been the party's intentions in respect of the ownership of the property based on the defendant's words or conduct? In 1990, as many of you will know, the courts dealt with the case of Lloyds Bank and Rossett. And the judge on that occasion, Lord Bridge, looked at how an intention could be identified, either expressly by reference to an agreement, as we've touched upon, or alternatively based on the party's conduct. And what he said was this: direct contributions to a purchase price would easily enable that common intention to be found. But, he says, as he read the authorities, it was extremely doubtful whether anything less will do. And it's really that part that I want to go into a little more detail with you all today. What less would do? Well, after Lloyds Bank and Rossett, you will all be aware of the case of Stack and Dowden. And in that case, Lord Wilson thought that things had moved on since the 90s and that you could look much more widely at the conduct of the parties and things that they did in order to infer a common intention. But in a sole name case that came very shortly after Stack and Dowden, the case of Morris and Morris, it was said by Sir Peter Gibson that in the absence of financial contributions, a common intention constructive trust based on conduct alone would only be found in exceptional circumstances. What, though, might those circumstances be? Well, what about working for the family business? In James and Thomas, the circumstances were of a cohabiting couple. The claimant had undertaken considerable manual labour working with the defendant's business and contended that that was sufficient conduct from which the court should infer a common intention to share in the property. And this is what the judge concluded. First of all, you see in the first quotation on the screen that the judge did not accept that that was of a sufficiently exceptional nature so as to lead to any inference that they were acquiring an interest in the farm, or that there was an intention that the claimant should. The lower point on the screen, which I would direct you to, is perhaps even more important. The judge recognised that parties in a relationship will often do things together, not because they intend to share a property together, but because they're making a life together. So when somebody worked for a business in this case, that was so as to create their life and not so as to necessarily create a proprietary interest in property. And we can see that line of reasoning carried through in more recent cases. which brings us to the 2019 case of Pillmore and Miah. In that case, again a sole name case, the couple ran a family shop together. The evidence of financial contributions to the property, which was alleged by the claimant, was unfortunately unclear. The case was therefore also run on the basis that a common intention to share the property should be inferred from their conduct in relation to the running of the business. His Honour Judge Kramer, who was sitting in the High Court, dealt with the claim as follows. Following the line of reasoning from James and Thomas, he agreed that in order for there to be an inference of an agreement to share the property, it had to be an exceptional case. And he took the view that taking part in the business of a spouse or carrying out works to a property do not give rise to such an inference in the ordinary course of events. The case of Pillmore and Miah also makes a point worth remembering. The evidence of contributions and indeed of conduct, particularly after many years, may be sketchy. But it's not the role of the court, the judge felt, to fill in the gaps or make assumptions about what was considered to be the party's intentions. As you can see from the bottom quotation from paragraph 42 of his judgment, the judge made it clear that the burden is on the claimant to prove their case. And as he says, if the evidence is unclear, the answer is for the court to say to the person who has to discharge the burden of proof that they've not proved their case. And so one can see the line of reasoning that's come since Stack and Dowden to looking at other kinds of conduct and whether they'll be sufficient in a sole name case to displace the presumption that equity follows the law. The case of Dobson and Griffey deals with a similar issue, making renovations and improvements to property. And I'm sure many of you will have encountered this kind of argument in cases that you deal with. It seems to me that this is often raised as a potential argument. The circumstances of that case were a cohabiting couple living on a farm in Devon. The farm was purchased in the defendant's name and with a mortgage in his name. It was alleged by the claimant that prior to the purchase, an agreement had been reached that they would share the property, and she said that she'd relied on that agreement to her detriment by carrying out various renovations and works at the property. The defendant said that there was never any agreement and argued that even if there had been, the claimant hadn't acted to her detriment in relying on that agreement. Again, we can see how the court approached it. In this case, His Honour Judge Matthews, again sitting in the High Court, not only concluded that there wasn't an express agreement, but also that a common intention couldn't be inferred by the parties' whole course of dealings in respect of the property. The judgment is also interesting for another reason, because it makes the point, or reiterates the point made previously, that when an unmarried couple's relationship breaks down, the court shouldn't approach it through the lens of Matrimonial Causes Act claims on a divorce. Instead, in unmarried couples cases, the court must approach it using strict rules of property. And under those principles, the court said that a property owner doesn't generally lose an existing property right unless they have expressly or impliedly agreed to do so. And so in a case such as this, where what was being relied upon was conduct for renovations and improvements, then in the absence of an express agreement to share, the court did not consider that those would be sufficient and exceptionally sufficient to infer a common intention to share in the property. What then did the court in particular say? We have it on screen here, and I invite you to read it afterwards. But the fact is again, the court reached the view that the claimant in the case had done the works, the improvements and renovations because she had decided to make a home with the defendant, to hopefully have children there, and that it's natural to think that the party would want to use their skills and ability to make the home as good as possible, not motivated by the fact that they were expecting to obtain a share in the property, as the judge says, making money from the circumstances. And so we can see along this line of authorities that the courts have very regularly refused to find a common intention based upon conduct. And that brings us up to the most recent of the cases that we are looking at. You'll see I've termed this slide a new direction of travel. And that's really because the most recent case suggests that we might be beginning to move back in a different direction. The case is a case called Amin and Amin from 2020, and it's a decision of Lord Justice Nugee, albeit sitting as a High Court in the High Court on that particular case. Now, as you can see on screen, Lord Justice Nugee took the case back to the simple and original principles and questioned whether the approach that's been taken since Curran and Jones of treating intention in two stages is in fact the correct one. What he says is this, and I'll read it aloud. It seems to me that the exercise that Lord Walker and Lady Hale envisaged is similar in a sole name case to that in a joint names case. In each case, what needs to be found to displace the presumption that equity follows the law is a common intention that the beneficial ownership should be something different from the legal ownership. And, save for a case where there's evidence of express discussions, this is to be deduced objectively from their conduct. He went on to say that if you then stand back from the detail, the broad question is always, what did the parties intend? Once one allows the party's intention to be inferred from conduct, it seems to me to make no sense to make a sharp divide between evidence that enables an inference to be made as to their common intention that the beneficial interests should not follow the legal ownership, and evidence that enables an inference to be made as to what they intended those interests would be. Those questions are necessarily bound up together. And so we can see from that approach that Lord Justice Nugee considered that the two parts of intention that one commonly encounters in constructive trust claims should in fact be looked at together. The judge then concluded as follows. In my judgment, the judge was right to say that financial contributions and many other factors could enable the court to decide not only what shares the parties intended, but also whether there was a common intention at all that the sole legal owner should not be the sole beneficial owner. What then can we take from this? Well, it seems to me that there is a potential new direction of travel, a new avenue that can be explored, that despite the run of cases suggesting that renovations or other contributions to a business are insufficient, that this most recent decision perhaps begins to tip the balance back in the other way and says that there are many other factors that you could rely upon to show an intention should be inferred. That then brings me on to the issue of detrimental reliance. Again, you'll recall that this is one of the two necessary components of a claim for a constructive trust in this area. It goes back again to the 70s. We know that as well as proving an intention, a party claiming the existence of a trust must prove that they've acted to their detriment in reliance upon that intention. Or what kinds of detrimental act would be sufficient? Again, to review the previous case law, we can perhaps understand exactly what's required. The case of Grant and Edwards dealt with the question of household expenses. And what it said was that payments towards household expenses might be sufficient, but not necessarily so. And the judgment of Lord Justice Norse is instructive in this regard. He said it must be conduct on which the claimant could not reasonably have been expected to embark unless she was to have an interest in the house. And so to take as an example, somebody who pays the heating bill or buys food for the household, the question is, would they have done that if they didn't expect to have a share in the ownership of the property? And in a great many cases, it can be argued that, of course, they would have needed to be heated and fed in any event. And so they haven't acted to their detriment in reliance on some common intention that they will have a share in the property. It's also worth considering under this principle whether the legal owner would have been able to continue to meet the costs of the mortgage if the other party, the claimant, hadn't been paying for other sums. That may provide an avenue for a claim. Bringing things slightly more up to date, we have the case of Curran and Collins, again a sole name case. And in that case, the claimant said that the defendant had provided an excuse for not putting her name onto the property. He'd told her that life insurance would be too expensive, and she said that she'd relied on this as evidence of an intention to share the property. At first instance, the judge found that the claimant had not acted to her detriment in reliance on that excuse or at all. And when the case went on appeal to the Court of Appeal, Lord Justice Lewinson looked at that finding and said that that in itself is fatal to Miss Curran's case. Now, what you can take from that, it seems to me, is you have to be specific about the detriment that is said to have been suffered by the claimant in reliance on a common intention, or your case will fail. It's fatal if there is no detrimental reliance established. Even more recently, the courts have given judgment in the case of O'Neill and Holland. The circumstances of that case are as follows. Again, a sole name case, and it concerned a family home that was purchased by the claimant's father in 1999 and became a home for the parties between 2000 and 2012. In 2008, so 8 years into their occupation, the property was transferred into the defendant's sole name. The claimant's case was that it would have been put into joint names, but only the defendant could take out a mortgage. When the parties separated in 2012, the claimants claimed that a constructive trust had arisen in 2008 when the property was transferred to the defendant. At first instance, a constructive trust was found by the district judge. The case was then appealed, and it went before His Honour Judge Pelling QC, who held that an act of detrimental reliance hadn't been sufficiently pleaded or established on the evidence by the district judge. The case then went on a second appeal to the Court of Appeal. On appeal, the claimant said that her detrimental reliance had been established on the evidence on the basis that she was worse off as a result of the transfer of the property to into the defendant's name in 2008. Well, we can see what the judge said about all of this. First of all, Lord Justice Henderson reviewed the decision of the circuit judge and said that Judge Pelling was right to hold that detrimental reliance remains an essential ingredient of a successful claim. So just like the earlier decision of Lord Justice Lewinson, where it was said to be fatal to a claim for that not to be established, we see here Lord Justice Henderson making the same point, that it is an essential ingredient. He then went on to examine the case that had been pleaded by the claimant. And the judge commented that if that case had been established, then there would have been no difficulty in concluding that the claimant had acted to her detriment in reliance on a shared common intention. The difficulty, as we see from the next slide, is that the district judge didn't accept that pleaded case, and in fact didn't accept either party's pleaded case. But what the judge did find was that there had been an intention for the property to be put into joint names, and that the reason that that hadn't been possible was because of an inability to obtain a mortgage. In the event, the judge accepted that the claimant had therefore suffered a detriment in reliance upon a common intention. He focused on what the end result was. He concluded that the claimant no longer had an interest in a property that she could have expected to have, it coming from her father, but for the issue of the mortgage. The judge took the view that that was a sufficient detriment to be able to rely upon to establish a common intention constructive trust. What then are the lessons to be learned in this regard? Well, the first, it seemed to me, was that one doesn't have to simply look at the acts, but also to consider the effect of alleged events, even if they were performed by a third party. So thinking about O'Neill and Holland, the act had been performed by the father and not by the claimant, but the effect had been suffered by the claimant, Miss O'Neill. The second lesson, thinking back to what Lord Justice Lewinson said and also what was said by Lord Justice Henderson about this still being an essential ingredient of a constructive trusts claim, is that you should plead reliance on those acts or events carefully. Because if you fail to do so, that in itself will be potentially fatal to the claim. And so I hope that those lessons you do carry, and what we see is cases of this nature making clear what the detriment is said to be, how it is said to have affected the claimant, and why they're in a much worse position than they would otherwise have been. And in those cases, a substantiated claim can be made out. I'm just going to stop sharing my screen with you now to hand over to Helen, who will pick up and present the second half of this webinar. If you can just bear with me.
Thank you, Paul. I'm going to try and share mine now, find out which screen is which. So that's the one I want to share. And I'm hoping that you can now see just a screen with slides. That is fine for you. I'm just going to check the chat box, which is now moved over here. Yes, yes, marvellous. Fantastic. Right, well, that was very interesting, Paul. And it does occur to me with the common intention constructive trust cases, that particularly in cohabiting cases, we always look at what the claimant says, generally the financially weaker party, and not really what the defendant says, and what their intention was when they in effect induced the other person to come and live with them, but not to have an interest in that property. And that's something I always find is very tough to grapple with clients. And then where we go from there with that, of course, cohabitee law needs to be looked at, and Parliament is doing still nothing about that. But it's a bit fairer, in my view, when we come to proprietary estoppel, but it's a question of being able to establish the ingredients of that. And that's what we'll be looking at here. And then in particular, looking at, once you've established a proprietary estoppel, quantifying the established interest, so quantifying the remedy that one might expect to see. We have a Supreme Court case coming up. It's due to be heard on the 2nd of December. We were hoping it would happen before now. Permission was granted on the 15th of December last year, so it's almost a year before they've even heard the arguments. And we don't know when we'll get the decision, but hopefully quite soon thereafter. But in the meantime, I'm going to speculate at the end of this as to what the outcome might be. So first of all, what is proprietary estoppel? Well, it's really quite an ancient doctrine that has gradually been given a name post-Hytrees. But here we are. What is proprietary estoppel? Well, according to Lord Justice Balcombe in Wailing and Jones, who was citing the judge in re Basham deceased, it's where one person has acted to his detriment on the faith of a belief which was known to and encouraged by another person, that first person has or is going to be given a right in or over the second person's property, then the second person can't insist on his strict legal rights if to do so is consistent with the first person's belief. And in the leading case, the still leading case on this, of Thorner and Major, Lord Walker of Gestingthorpe considered the scholarly consensus at that point, and went through and summarised it, precede those principles to state that it's now where A makes a representation or assurance to B, B relies upon that representation or assurance, and there is a detriment to B as a consequence of his reliance, it is reasonable for B as well to rely upon that representation or assurance, then the equity would arise that would need to be met. So those were the factors that Lord Walker determined a claimant would have to establish. There's also obviously, well, I say obviously, it may not be obvious, an assurance or representation by way of acquiescence. And we see first, one of the earlier established situations where that occurred was in the case of Dan and Spurrier, an 1802 case, where the then Lord Chancellor, Lord Eldon, said that this court will not permit a man knowingly, though but passively, to encourage another to lay out money under an erroneous opinion of title, and the circumstance of looking on is in many cases as strong as using terms of encouragement. So how do you establish that assurance or representation? Well, again, Thorner and Major deals with that. The promise has to be unambiguous, and it must appear to have been intended to be taken seriously. It must have been a promise which one might reasonably expect to be relied upon by the person to whom it was made. And the estoppel doesn't look forwards into the future and guess what might happen. It looks backwards from the moment when the promise falls to be performed and asks whether in the circumstances which have actually happened, it's unconscionable for that promise not to be kept. So we have two current leading cases, really, when we're looking at the remedy issue. Both of those cases also look at all the criteria that proprietary estoppel demands, because you have to go through that before you obviously get to the remedy. But the two leading cases are Court of Appeal decisions, one from 2016 called Davies and Davies, and then the more recent one in 2020 in the Court of Appeal, 2019 at first instance of Guest and Guest, and that's the one that's coming up in the Supreme Court. Permission to appeal in Davies and Davies to the Supreme Court was refused at the conclusion of the Court of Appeal decision. So in Davies, all of these cases pretty much, well, the majority of them are farm cases, and they all share common themes. Low pay, doing hard agricultural work over many, many years on the faith of a promise that there will be an interest of some description in the farm business, the land involved with the farm. They all pretty much have the same themes. And it's a real issue, as I understand it, in farming literature. They often have articles about what has happened recently in various cases that have appeared in the High Court in relation to proprietary estoppel. It's something that does impact upon a lot of these long-established businesses, agricultural businesses. So in Davies and Davies, the claimant, Arian, I'm sure Paul will tell me if I'm pronouncing her name incorrectly, she was the middle of three girls of her parents who had owned and ran a sizable farm. Arian was the only one of the three daughters who showed any interest in working in agriculture. And from the point that she left school, she started working on that farm and for a very low agricultural wage. Her parents gave her expectations that the farm would become hers, but there were disagreements between her and her parents over the years. She worked solidly there from the age of 17 to 21. She then left because she had a falling out with her father. She married. She went back to work, but she did not go back to live on a farm. They bought, her parents bought another farm and she moved in there, but she still worked on on their farm. She suffered, the court found, some pecuniary detriment in reliance on her parents' representations. But other detriments, such as working elsewhere, was more difficult to quantify. She hadn't positioned her whole life around the representations. In that case as well, the representations changed over time. It was that if she worked really hard, she would get the farm when they died. Then they changed that and determined that they would offer her something else, and she wasn't content with that. And there was eventually another falling out, and she left the farm for good. But she had been very successful in running a farm at her parents' property. She issued a claim under proprietary estoppel, and her problem was really establishing what the representation was that she had relied upon to her detriment, because that changed over the various periods during her period of working there. As I stated, she had not positioned her whole life around the promises that had been made to her. She had gone and found work elsewhere eventually. She had sought to set up a farm elsewhere as well, but she wanted to be able to run an equivalent farm herself. Her parents argued that there was no representation upon which she could rely at the point that she brought her claim. But they were found to be incorrect on that point. That then went up to the Court of Appeal and back down again, because the court had decided to treat it as a split hearing, and it is well established now proprietary estoppel cases should be heard holistically in the round. We shouldn't have determining whether or not there is an assurance in the first place, and then determining if there is that assurance and a detrimental reliance, what the remedy should be, as happened in Davies. On the remedy issue, she was awarded at first instance £1.3 million value, which was the net value of the farm and business, and the intention was that she would receive that and then would be able to set up her own business elsewhere. But unsurprisingly, her parents appealed that, because it ultimately meant that the farm would have to be sold and they would lose their own business. That on appeal to the Court of Appeal, that was reduced to 500,000. And the reason being that the court at first instance had gone too far in meeting Arian's disappointment. What the Court of Appeal, and again it was Lord Justice Lewison who did the leading judgment, what the Court of Appeal said in that case was that the representation that she was relying on at that point was that she would have a home for life on the farm, and that was what she was working towards. That was the detriment that she had worked towards to make sure she had to live there rent-free for life. That was the expectation. And her parents, in offering the £350,000 originally, meant that it was enough to establish that she would have her mortgage paid off in her own property elsewhere, and she would have compensation for coming out of the farming partnership, which is what had happened. The Court of Appeal said it was too much to say, well, she should have enough to go and set up a complete farm elsewhere. But what she should have was the provision for paying off her mortgage, because that satisfied the detriment. The expectation of a share of partnership profits and company shareholding, that had to be satisfied. And they also had to satisfy her expectation of an inheritance to a sufficiently high level, although her expectation on that front was too high. So some allowance would be made for that, but not what she expected. And they had not satisfied her non-detrimental reliance of her curtailed ability to work shorter hours in an environment of her choice. And that could be done by a modest financial award. So the Court of Appeal lifted the parents' original offer up to £500,000. There was a subsequent application to the Supreme Court, but that was refused. In that judgment, Lord Justice Lewison set out a set of 9 criteria that have been relied upon subsequently in almost every proprietary estoppel case that has occurred since then. And I'm just going to whip through them for you. Again, they're all based on the previous decisions, predominantly Thorner and Major, and a Privy Council decision as well called Henry and Henry, and Jennings and Rice, another decision of Robert Walker when he was a Court of Appeal judge, is also a significant driving factor in all of these cases. So in Davies at paragraph 38 is where you find this checklist. The first criteria is when you decide whether an equity has been raised and how to satisfy it, you look backwards from the moment when the promise falls due to be performed and ask whether, in the circumstances which have actually happened, it would be unconscionable for a promise not to be kept, either wholly or in part. And of course, I've already mentioned that earlier. And then the ingredients necessary to raise an equity are an assurance of sufficient clarity, reliance by the claimant on that assurance, and detriment to the claimant in consequence of his reasonable reliance. But no claim based on proprietary estoppel can be divided into watertight compartments. The quality of the relevant assurances influences the issue of reliance. Reliance and detriment are often intertwined, and whether there's a distinct need for a mutual understanding may depend on the other element, how other elements are formulated and understood. Detriment doesn't have to be money or other quantifiable financial detriment, although the later cases do tend to separate the question of detriment into financial detriment and non-financial detriment, but it has to be something substantial. The requirement must be approached as part of a broad inquiry as to whether repudiation of an assurance is or is not unconscionable in all the circumstances. There has to be a sufficient causal link between the assurance relied on and the detriment asserted, and the issue of detriment has to be judged at the moment when the person who has given the assurance seeks to go back on it. The question is whether and to what extent it's unjust or inequitable to allow that person to go back on that assurance. The essential test is unconscionability. And so the essence of proprietary estoppel is to do what is necessary to avoid an unconscionable result. When you're looking at satisfying the equity, the court has to weigh the detriment suffered by the claimant in reliance on the assurances against any benefits they've also received in consequence of that reliance. And proportionality lies at the heart of the doctrine of proprietary estoppel. There must be proportionality between the remedy and the detriment, not the remedy and the expectation. Proportionality between the remedy and the detriment. This doesn't mean that the court abandons expectations and seeks only to compensate for detrimental reliance, but if the expectation is disproportionate to the detriment, the court should satisfy the equity in a more limited way. So in deciding how to satisfy the equity, the court has to exercise a broad judgmental discretion, but the discretion is not unfettered and it has to be exercised on a principled basis, not with a portable palm tree. So subsequent to that, there was a decision of More and More, which was considered by Mr. Justice Burse as a first instance judge and guest as well. And in More and More, the claimant had worked consistently again on his parents' farm in the expectation that he would eventually receive it. Those were the promises made to him by his father in particular. He became a partner in the business in 2003. His uncle left him his half share of that business as well, on the basis of the representations that the father had made to both the uncle and to the claimant. And in 2007, his parents executed mirror wills, leaving his father's interest in the farm on the death of the survivor of his parents to their son. The relationship with the parents broke down, the parents revoked their wills, and the father dissolved the partnership. It's often a case that the relationship breaks down over differences in how the family want to run those businesses as well, rather than necessarily anything personal. At first instance, the judge found that the claimant had been promised the farm, partnership and assets, and he'd acted to his detriment and reliance on the promise. And the first instance judge thought that he should mirror the arrangement which would have obtained if the dispute hadn't arisen, and ordered the transfer of the business and the property to the claimant subject to a license to occupy the farmhouse in favour of the parents, and an order that the claimant pay his father £200 a week and cover the parents' care costs. Now, his father was very, very ill at this point. In fact, had gone into a care home by the point that he was that the trial, or certainly by the time it came to the Court of Appeal, and the mother was elderly and needed help. And this £200 a week was quite a minimal sum of income that the Court of Appeal ultimately said was inappropriate. The Court of Appeal, on the parent's appeal, said that this accelerated and exceeded the son's future expectation. He didn't have an absolute right to capital and income while his parents were alive. And the arrangement that the first instance judge had made meant that he would be continued to be locked in a continuing financial relationship with his mother, and that this was a case where a clean break was appropriate. And the order didn't take account at all of the tax consequences of the order that was made, which were significant, both inheritance tax and capital gains tax. And that needs to be done as well in these sort of cases. The costs on both sides, by the time it had reached the Court of Appeal, were 2.5 million. The size of the estate was about £10 million. It was really disproportionate by then, but the Court of Appeal would not substitute its own judgment, although the leading judgment, I think that was Lord Justice Floyd in that case, gave a very long checklist to the first instance judge when they remitted the case to him to tell them basically what the outcome should be. And that is found at paragraph 102 of the judgment. And there is a note coming around after this hearing in which that's all set out, after this hearing, after this seminar. So you can see exactly, basically, that the Court of Appeal said, we're not making a decision, but this, judge, is what you should be doing when you come to look at this again. There's then Haberfield comes next. And again, this is a case in which a middle daughter, in fact, was she the middle daughter? She was one of 4 daughters, the only one interested in running her parents' farm, worked on it night and day for 33 years. The parents assured her throughout that once they couldn't run the farm any longer, it would pass to her, subject to some provision for her siblings, and including that the title would remain with her parents during their lifetime. The parents in 2008 offered Lucy the chance to join a partnership with them. She rejected that because it meant that she did not have control over the farm. She'd still be a partner with other people with whom she clashed on the way that she thought the farm should be run. She left the farm. In 2014, her father died, and in 2016, she issued proceedings seeking transfer of the farm and the business to her. And of course, her mother, still alive, in her 80s, and in a very difficult position as a result. The court found that there'd been assurance, detrimental reliance, both financial to the value of £220,000, that was quantified, and non-financial detrimental reliance. And to satisfy the equity, the judge ordered an immediate cash payment of 1.1 million in an attempt to avoid the negative tax consequences of having to separate the farmhouse from the land in order to effect a sale of some part of the land to meet that, and to prevent Lucy's mother from having to leave the house. And Lucy didn't want that to happen either. Again, that was dealt with in over 2 hearings. There was the initial judgment, and then there was how to put the remedy into effect. And the mother said, well, look, I simply can't raise this 1.1 million. I will have to sell the whole farm. I cannot sever the farmhouse from the land. Nobody would be interested in that. And the judge said, well, tough, I'll give you 14 days to come up with the money, or otherwise the whole thing's going to have to be sold. And the mother appealed, saying that the offer of the partnership in 2008 satisfied any equity that Lucy could have expected. She rejected that, and so she shouldn't have any subsequent expectation. The award was disproportionate to her loss of £220,000 and the non-detrimental reliance, which she couldn't be relying upon anyway because it wasn't there. and that any award should be deferred until after the mother's death, so as to raise the sum raise the sum for the farm and farmhouse after her death, so that she wouldn't be ejected. And the Court of Appeal found that although it was a really harsh outcome for Jane, her appeal would be dismissed. The rejection of the 2008 proposals and keeping working thereafter didn't mean that Lucy received nothing, and it wasn't suggested at any point that her inheritance would be forfeited by virtue of her dismissing that proposal of partnership. Lucy continued to rely upon the earlier assurances. And the relief granted by the court was not out of all proportion suffered to in relation to the detriment. There was a balance of Lucy's expectation against the interest, but they had made a bargain. Lucy had met her side of that bargain, and so it was unconscionable for Jane not to do so. And there had to be a clean break in this case. There would be enough left over to rehouse Lucy's mother and also to provide her with sufficient income as well, on the basis that the whole thing was sold. So although the Court of Appeal said, I might not have made the same decision, they were persuaded by Lucy's counsel that they shouldn't interfere with the first instance judge's decision because it was not plainly wrong. Then we have Guest, again, another farming case, another case in which a son works really long hours for his family. There's a falling out about the direction in which the farm is going. The court in this case, first instance, referred repeatedly to the checklist at paragraph 38 of the judgment in Davies, also considered more, and decided ultimately that Andrew, having met his side of the bargain, the remedy was to provide him with that which he could have expected to have received on his parents' death, namely 50% after tax of the market value of the dairy farming business and 40% after tax of the market value of the freehold property, subject to a life interest in favour, sorry, I'm just about to turn off all my screens, subject to a life interest in favour of his parents. That didn't meet Andrew's original expectation, but it did meet everybody's position in evidence. David and Josephine, Andrew's parents, appealed to the Court of Appeal. That failed, but they were granted permission to appeal by the Supreme Court. And the point that the appeal is considering is what should be the correct outcome. Subsequent to Guest, we have a share case, so not a farm, in which Mr. Andrejewicz, you may be familiar with him in relation to contempt proceedings, owned a property investment business, set up a holding company through which he bought various properties and a home in Chelsea. He had a long-running relationship with a cohabiting partner, and 2 years into that relationship, he transferred to her all his shares, or all the shares that were in that holding company. He got other business partners to transfer them to her as well, asserting that that was to protect their home from creditors. They had 5 children together. 18 years later, there were difficulties in the relationship. He waged a campaign of attrition and harassment against her and engaged their 14-year-old son in getting her to sign a trust document saying she had no beneficial interest in the shares. She left the home with 4 of those children. And she issued claims for a determination of her beneficial interest in the company, saying she was the full beneficial owner as well as the legal owner, or otherwise that he was stopped from denying that ownership, or that there was a common intention constructive trust on a 50-50 basis and a fallback claim under Schedule 1 of the Children Act. Mr. Justice Cobb said that she was the sole beneficial owner of the shares. He would have been prepared to find that Mr. Andrejewicz had made material representations to Ms. Montroy about her financial security in the property, and she had acted to her detriment on those representations. and he was stopped from denying her claim, and she should get the remedy, which was the entitlement to the shares. Then there was Hughes and Pritchard. That was regarding the validity of a will. It did involve a farm. It's a parcel of land that was devolved under this will to a son who had predeceased the deceased. But under the will, sorry, I'm confusing myself here. Under the will, the parcel of land went to a living son. There had been a son who had predeceased the deceased, Elvid, and Elvid had worked on the farm with his father, the deceased, and had been promised over, of course, many years that the farm, this parcel of farmland would come to him. On that basis, he persuaded his own son to give up his well-remunerated job to come and work the farm as well, on the basis that Evan, Geraint's grandfather, had promised it to Elvid and Evan. And that, in fact, was confirmed by Evan to Geraint after Elvid's death. But it was found that, firstly, the will was invalid as a result of want of testamentary capacity. But even if it hadn't been, the court went on to consider the various other claims that were made against it and decided, in relation to a proprietary estoppel claim, that was satisfied. And there were two clearly established principles. The maximum relief is what is needed to honour the promise, and expectations arising from the promise will not necessarily be honoured, and the court will not grant relief out of all proportion to the detriment. And the court in that case considered both Haberfield and the checklist in Davies referred to earlier. There is then Pickering and Hughes. This was a case in which a proprietary estoppel claim was brought and was dismissed because firstly, there hadn't been an agreement, representation, or common intention in that case. That was ultimately the finding. But even if there had been, or if there had been a suffering of a detriment which supported a claim for an assurance agreement or representation, that detriment was outweighed by the benefit of living rent-free for 30 years in a much more impressive and commodious home than that which the claimants owned elsewhere. So that's a case in which the detriment was met by a countervailing benefit. So what's the Supreme Court going to decide? Well, it's my view that given the way that every single case pretty much since Davies has considered the checklist at paragraph 38 of Lord Justice Lewison's judgment in Davies, that is the correct summary of the law. They might tinker with it, but it does look like that will be the correct summary of the law. The quasi-contractual arrangements where one party has fulfilled their side of the bargain and the other party has resiled from doing so are likely to be remedied by meeting the expectation, provided the detriment is sufficient. That has to be, the expectation has to be proportionate to the detriment suffered, and in that case, the remedy will be proportionate to the detriment as well. Benefits obtained will, of course, be taken into account and discounted from any remedy, and the benefit obtained may obliterate the detriment, as was the case in Pickering and Hughes. Where the assurance or representation changes over time, such as in Davies, then the expectation is likely to have changed with it. And it may be disproportionate for a claimant to cling to the promise of an earlier assurance which conflicts with a later one. But where there is a continued reliance on those assurances, which is commensurate with the detriment suffered, an equity will arise that will have to be met, albeit that it may be further away from the expectation held. And in meeting the remedy, the parties asking for it and the court in granting it must be alive to the consequences of it, including both the impact on the claimant and the defendant and any tax consequences, and take those factors into account when considering the proportionality of the remedy. So you must have, in these claims, tax evidence. That's something that in Moore they said they need, you've got to have evidence of the likely tax outcomes and values of property that are an issue. And again, they didn't have that in Moore. Thank you very much. I know we are beyond time. Apologies for that. There have been some questions, and I'm hoping you will stay for a little bit more so that we can look at those questions.
Helen, should I perhaps deal with the first of them in
Yes.
time? We had a question during my part of the webinar asking about whether we are circling back to the point in LeFaux where the issue is about whether helping with expenses will be enough to establish a common intention constructive trust. It seemed to me that in answer to that question, the issue is not so much with whether somebody makes payments expecting that they're going to obtain an interest in the property, because that would be to focus on their own intentions in respect of the property. And what one really should do is turn the question round and say that was it reasonable objectively for a person in the position of the claimant to understand that the property owner was only allowing them to make those payments because they were going to be obtaining an interest in the property in exchange. And so when one then thinks about payments towards household expenses, heating, electric, or food, it seems to me that in most of those cases, the legal owner wouldn't be allowing the person to pay for that simply on a transactional basis, giving up part of their ownership in the property, and that it's very common for people to share outgoings just because they live together, like they would if they'd been renting, for example. And so I agree that it's a difficult point, but that in most instances, the courts have been saying that's not sufficient. And although Amin and Amin is perhaps beginning to tilt the direction back in the other direction, I don't think with outgoings and expenses, it's likely to be found in many cases that an intention to share was to be inferred. There's a second question, Helen, I don't know if you want to deal with this one or I can. It asks, should open offer letters be sent in TLATA proceedings if TLATA proceedings are being considered, or should it be done via Part 36? I don't mind answering that, or Helen, you, by all means.
Oh, well, yes, well, certainly my view is if you can make open offers, that's always useful. More open, the better. And your letter before action or letter before claim will have to be open, and will have to set out your claim clearly enough anyway, if you want to rely on it later in costs arguments. I mean, that's another thing that the court has to consider ultimately when they're giving their judgments, and again was addressed in Moore, actually is what the likely costs outcome will be, where you end up, because of course in these cases, costs are relevant at the end of it. And if you're going to undermine the remedy you make by making cost orders, or you put a defendant in a very difficult position, then particularly where they're elderly and vulnerable, then that needs to be taken into account as well as part of the benefit detriment issue in proprietary estoppel cases. Can yes.
I add one other thing, Helen, on Part 36? Well, really two things. The first is to make sure that everyone remembers that Part 36 offers are considered to be given without prejudice save as to costs. So they can't be referred to until the end of proceedings. I'm sure everyone has that. The second thing is to think about the consequences of them. there are different consequences if you're a claimant or a defendant. If you're a claimant, there are additional benefits to making a good Part 36 offer, which in some instances can make a big difference to your client's potential prospects in rehousing. And so, for instance, the fact that you get an additional up to 10% sum reflective of the award that's made in damages, that you get your costs on an indemnity basis, that you get interest on those costs up to 10%, provided it's not unjust to order all of those things. And so where the money is quite tight, that could be 40, 50, 60,000 pounds worth of difference, which dramatically alters one party's rehousing. And so my view is that a good Part 36 offer not only serves to put the other side under pressure to reach a settlement, but that also can provide the additional benefits which give better outcomes for clients at the end of a case if it's not accepted. So I think there's a place for both. Open offers, just like Helen says, have a lot of value because you can tell the court how reasonably you've acted all the way through. But Part 36 offers because of the potential consequences.
I agree with that. I would also say about Part 36 offers is it's only, certainly my research, my experience of that has been it's only really worth issuing them after you have issued the claim, because it's very difficult. There are subsequently arguments about whether or not it would actually, you would get your pre-action costs if you issued it before then. Whereas called bank offers are also, so without prejudice save us to costs, which aren't Part 36 offers, don't have the consequence of Part 36, are also very useful. If you're making a Part 36 offer, do it on the standard form, which means that you are unlikely to get it wrong and undermine your own costs arguments at the end. I can see there's also been a question just before we go on to the the subsequent question to that cost point. There's been a question at the end saying, if no letter of claim has been sent, is this fatal to claimants' cases on costs? It's risky. Not sending a letter of claim means you're not complying with the protocol, the pre-action protocol, and there are potentially significant cost consequences in not doing so unless you've got a really good reason for not doing so. But obviously you're meant to try and settle everything before you even get to court, if you can. And so good quality letters before claim can be very, very useful, and to be sent with enough time to be able to consider it, properly mediate, civil mediation, and hopefully reach an accord rather than entering really ruinously expensive litigation in these sort of cases. Because they're so fact specific, it's very difficult to say what the likely outcome will be, notwithstanding all the checklists, notwithstanding necessarily what the Supreme Court will say subsequent to the decision in Guest.
Yeah, I think I would add to that, if I may, that just like the situation where 40 or 50,000 pounds can make a considerable difference to a client's rehousing prospects, failing to serve a pre-action letter and ending up being punished in costs could have a commensurate detriment to your client of 40 or 50,000 pounds, which would be very considerable in terms of their future housing. The other thing to mention, of course, is that these claims will typically be allocated to the multi-track, and so there is a process of cost budgeting that the courts will go through, and that therefore arguments about the failure to comply with the pre-action stage might be able to be flushed out at that on that occasion. Once there has been approval for costs by the court and agreement, so far as there is any, on those budgets, then the prospect of the court saying, well, we're not going to allow anything because you didn't send a pre-action letter is probably, in my view, reduced. But that's not to defer from the pre-action requirements. I thoroughly encourage, just like Helen, the sending of those letters and trying to resolve things without needing to litigate in the first place.
The final question we've had is about coercive control cases, where one party runs up significant debts in others' name with promises of repayment. Can it be possible to use a claim, shield not a sword? Well, proprietary estoppel is a claim in itself. That's been established. It's not the same as promissory estoppel, which is only to be used as a shield and not a sword. So you can use it as a sword. Where one party runs up significant debts in others' names with promises of repayment. What's the property in which you are establishing the claim? That's the issue there. What's the expectation? I don't know about claims in relation to just money, or where someone's taken out debt in your name, whether or not that's potentially a different action than proprietary estoppel. Paul, what do you think? I don't even know what I think really about that.
No, I think what you would have to try and do is think about how that could be framed within either a claim for a constructive trust or on the grounds of proprietary estoppel. You're then looking at those component parts and trying to say, by virtue of what happened, the running up of those debts, it should be either on a constructive trust base inferred that there was an intention to share in some property that didn't otherwise exist. Well, that might be possible, but I think it's probably somewhat tenuous. On a proprietary estoppel basis, that somebody says, well, I've suffered the detrimental part of that sort of claim because of what happened to me. Again, perhaps possible, but I think unlikely. It would be an interesting question to try and answer, but probably quite full of risk to resolve through the courts.
Yes, I wonder if it would be, yes, to say, I was just thinking about secured interest in properties, but you'd still have to have the interest in property to have a charging order placed against that property. So if you ran up debt in somebody else's name, subsequent charging order is placed on the property in their name. We're getting more detail. Is this actually a case, is it, Julia? 100,000 credit card debt, personal loans. If that were to be secured against that person's property, then what's the claim? You're saying, well, there's detrimental reliance there and trying to get that back from them, but they haven't established an interest in your property to do so. That's difficult. That's something to think about, I think. I can't answer that straight off the top of my head.
No, I think it probably does bear some more looking into.
Yes.
We've already well extended the time this afternoon, and we don't want to take you away from your busy lives. We hope that that's been really helpful to everybody. Of course, we're here to assist you with these kinds of claims when they come along. So on behalf of both of us, just to say thank you very much for attending this afternoon. As I said, it's lovely to see so many people making themselves available to come along.
Yes, thank you very much.
Thank you, everyone. Have a good afternoon.